The next frequently asked question is, um, must the landlord give the tenant notice before initiating the eviction process? So yes, the answer is generally yes. So there's three major types of evictions. The most common is for non-payment of rent. Typically, the landlord has to give the tenant a 3-day notice. It's a 3 business days. So you don't count the date of delivery, and then you count every business day thereafter. And there's special rules if you live outside of the county or if you're trying to mail the 3-day notice. But if you live in the same county as a tenant and you want to deliver a 3-day notice, then the date you deliver it doesn't count. And then there's 3 business days after that. And to determine whether a day is a holiday or not, you have to check your local county's clerk of court's legal holiday schedule. But typically it'd be 3 business days. You don't count the date of delivery. They get 3 business days. That's a 3-day notice for non-payment of rent. That's the most common notice that's required for an eviction. For other types of violations of the lease, for example, if there's a unauthorized guest, if there's an unauthorized pet, if there's something like that, then you would deliver a 7-day notice. There's 2 types of 7-day notices. There's one with the right to cure and one without the right to cure. So typically, the one with the right to cure is things for unauthorized guests or unauthorized pets and things like that. Generally, the tenant has the right to fix whatever they're doing wrong before you start the eviction process. Excuse me. The other type, the 7-day notice without opportunity to cure, are typically for things that are worse. For example, purposeful destruction of the property. In that case, the landlord wouldn't be required to um, give the tenant an opportunity to cure any violations. At the end of the 7-day notice, the lease is terminated, whether it's cured or not. And the next type of notice is a notice of non-renewal. So if the lease is about to expire, or if it's a month-to-month, then the landlord can deliver a notice that the lease will not be renewed. The statute says that for a month-to-month lease, the notice has to be given 15 days before the end of the term. Most people have a rental agreement where rent is due on the first, so the term would be from the first to the last day of the month. So if you want to terminate the lease in any month, you would have to deliver the notice at least 15 days before the end of the term. So generally by the 15th of the month. If it's February, you have a little bit less. You have to do it by the 13th of the month if you want to suspend it for that date. Something else to keep in mind: the county where we're in, Hillsborough County, the city of Tampa, Pinellas County, and the St. Peters and the city of St. Petersburg, they have put out these tenant bill of rights, and those municipal codes sometimes require longer notice. I believe in the city of Tampa, for example, the landlord is required to give 30 days notice of non-renewal. So those are typically the 3 types of notices: the 3-day notice, the 7-day notice with or without opportunity to cure, and the notice of non-renewal. After those notices are given and they expire, if the tenant has not complied with the notice, then the landlord can start the eviction process.